For me, this is the way of giving back to the ecosystem because ultimately this ecosystem has shaped me and I ensure that the next generation has all the tools to compete globally because Indians should be competing globally.
Hello and welcome to yet another episode of Superlawyer at YouTube channel. Today we have with us distinguished lawyer in intellectual property, Mr. Nilanshu Shekhar sir, who is the co-founder of KAnalysis and a seasoned IP strategist with more than 2 decades of experience. Merging his engineering background with legal acumen, he delivers holistic IP solutions from protection to global monetization. He is also committed to empowering startups and fostering IP awareness across India and has a vision to make India a global IP hub. Welcome, sir, and thank you so much for being here. I hope you enjoy the conversation with us about your journey and challenges around and in intellectual property all around India, especially. Thank you, sir. Let me begin with asking you about your decision of doing law after having an engineering degree or academic foundation in biotechnology and industrial microbiology. What was the inspiration of yours in bringing in intellectual property in your life, and how have you taken this approach to excel in IP domain and make it a passion?
As it happens with everybody, the shift to intellectual property from engineering background, or in my case, the shift from biotechnology and industrial microbiology to IP was not planned. It happened organically, and I began my career as a patent engineer in my first organization, where I was introduced to the world of IP. And that exposure was an eye-opener for me because I realized IP was the perfect intersection of science, law, strategy, and business, more importantly. It allowed me to stay close to innovation while also influencing how innovations are protected and commercialized. So that is something that brought me towards IP, and the interest has kept me going till date. Because over time, this technical to legal transition has shaped my entire approach about how I view IP. I don't look innovations in isolation. I view them as a larger part in terms of the scheme of things of innovation journey, because it's all incremental and it doesn't happen as a eureka moment. So all those things and the mindset continues to influence how I advise my clients even today. Whether it's a startup or it's a multinational who is trying to scale its IP, I try to see the bigger picture, what the innovation would mean to them, how it aligns to their business goals, how to strategically protect it. Because IP as such in isolation with business is of no use. So that's how my journey towards IP keeps me motivated and going strong.
Thank you so much for bringing in this aspect of intersection of two fields, which are absolutely niche of the niche fields. So way back in 2007 itself, you started KAnalysis, and right now you have made it a thriving IP law firm. What were some of the key challenges during those early years when you started your journey with modest 3-member team and navigated it through building a firm this size and well known with a mission of making IP hub in India? How have you done it?
Well, it has happened gradually, I would say. When we started in 2007, we were working out of a single basement with very limited resources and zero clients. So the initial challenge was how to show your credibility. Why would anybody trust a young firm or somebody who has just started? And we focused on quality, responsiveness, and trust, because trust is something that would take you long. And even during our initial phase, we were doing the IP work wherever we were trained. We were not good at starting or setting up a business, managing cash flows, or getting clients, getting an introduction to a client. Because we could execute project, we could write a patent, we could search for a prior art, or we could do a lot of things. But how to convince somebody to trust you. So those were tough days, initial days, as it happens with everybody. But the real challenge started as we grow. Because when you try to scale, the biggest challenge is you should not dilute your core values. Consistency and patience is the key. But we have over time invested in people, set up robust processes, and being from the engineering background, we could incorporate and adapt technology at various levels. So, people, process, and technology, I would say, are the three pillars that we have not compromised till now. And the culture is that we would not compromise on, howsoever big we grow. Because growth at the cost of culture and quality would not last long. So, over the years, it has been almost 18 years, we have built slowly, steadily, investing in people, processes, and technology. That's what I claim to be my biggest challenge now. As the team grows, now we are over 100 people. Majority of my team is in India, but few members are spread across the globe. The second largest team size is in the US, and we have small offices spread across the globe to take care of various jurisdictions. So every step has a new challenge. And as we grow, the challenges keep on changing, but you have to adapt and you have to survive.
You have been resilient and you have prospered through that. Keeping all that and working towards IP rights for these many years, more than 18 years now, what was the role of your engineering background in shaping the strategies that you particularly saw were different from regular lawyers? Because obviously there was a different understanding of having an engineering background plus having the legal understanding as well. How have you seen that particular combination help you and help your team grow and strategize at the same time?
Yes, I have a different take on this. Whatever course or degree you undertake or exercise you take, it shapes your mind to think in a particular way. That's what engineering does. Engineering doesn't teach you anything. It makes your mind train in a particular direction, to think in a particular direction, to solve a particular issue or a problem with a different bent of mind. So engineering teaches you to deconstruct a problem, break down the system into fundamental parts and look each part individually, and then see the function and assimilate them. Law, on the other hand, teaches you to analyze. Law teaches you to connect those individual parts in a logical and legal framework. So having a training in both aspects help you see the final picture without missing the finer details. So that's what engineering and law and the combination helps you achieve. Initially, I was more involved into patent prosecution. Now, over time, I was exposed to IP litigation, which has added a third dimension to my thinking. Because when you are prosecuting patents, your basic idea is to get a patent. When you go into litigation, you realize the basic idea is how to get a patent which is enforceable. So it teaches you what holds in court and what falls apart. And this practical insight sharpens my instincts in the entire scheme of things. Because you also now try to look for the best claim scope or how to draft better claims. Because as a litigator, I have realized that my drafting or seeing of claims has also increased. So claims should be broad enough, assertable, and it should be defendable if there is an attack even after ground. So all those things shape up your thinking, and every day is a learning, I would say. Every case teaches you something or the other. So whether I'm guiding somebody, I'm not just looking at getting the examination and getting a patent, but how much I would contribute to get an enforceable patent. Because my goal is to create IP that is not strong on paper. It should stand the scrutiny. It should attract investors. It should survive litigation, both offensive and defensive. And it should support the business in market entry. So starting and setting up my business also helps me understand what are the key challenges any company faces with regards to IP protection. You don't go all out and spend all your money on IP. Business is also important. So it's a combination and it's a learning that has helped me consult client, because I don't work with clients as a service provider or as a lawyer. I work hand in glove, suggesting them. Even I suggest them on who to go for a merger or whom to not partner with, or those kind of activities I also undertake regularly. And that's where I like working with early stage startups or small tech companies, because there you can be invested with them very closely. And with time, I have seen that most of my clients trust me, because we make them understand that IP isn't just about legal protection, it's a business asset. So technical understanding, legal foresight, and business acumen, that's why we have been successful as KAnalysis, I would say. Because my clients, I have seen them right from their first provisional patent to securing multi-million dollar funding. So those have been brilliant experiences.
We would also love to understand that particular monetization process and the multi-million dollar deals that you have done for IP monetization, especially. But before that, we would love to ask you about your pro bono work also, that you have invested a lot of your time in the initiatives like IP help desk for startups and IP workshops that you keep on doing. What actually fuels your dedication to promoting IP awareness and educating academicians and entrepreneurial communities related to this? Because you do it pro bono and you also are involved in a lot of deals which are for monetization. So how do you find the balance in these two, and how do you find time for doing that?
That's interesting. I'll tell you a very humorous anecdote that when I joined IP, it was very difficult to convince my dad, what am I doing? And he's a professor. So that is the level of IP awareness in India. And it took me a long while, because India has no dearth of innovation. But IP awareness and awareness around IP rights remains uneven. Startups, academic institutions, big companies have their setup because they have realized it the hard way. They have been sued or they want to protect, they have mechanisms. But startups and academia lack IP awareness. And over the years, I have been working, we are managing one of the largest patent portfolios in India. We are managing portfolios in over 80 countries, spanning over 30,000 patents. So handling that kind of a portfolio, I realized that most of my clients are from outside India. And during COVID, you get time to ponder a lot about what are we doing? What are we giving back to the society? So during those days, I realized let's start IP help desk to help startups, because startups are at the most gullible phase. I have seen investors who are real sharks would take over them with their hard-earned innovation and everything. So I launched the IP help desk just to help them understand their questions, their issues, and guide them or handhold them without charging them. Because initially they're short on money and they think everybody is trying to sell something. So I have done over 150 pro bono workshops across the country in the last 2.5 years. And these are not just lectures, they are conversations where I help to demystify IP to the founders, to the initial incubation center, people who have started in the incubation center. And I give them practical, usable advice. How to stagger cost. How can you protect yourself with minimum cost so that when you attract investors, you may pay me. But how we can get to that stage where you are attractable to the investor, I would say, and being protected. Because IP should not be an afterthought. It should be part of innovation process from day one. Founders, researchers understand their rights, the value of protection. That's what I do. I try to make them understand that where the value lies, it's not a cost center, it's an asset. And slowly and gradually, I'm assisting over 1,000 startups at the moment who are transforming their trust in me, and their confidence and outlook. For me, this is the way of giving back to the ecosystem, because ultimately this ecosystem has shaped me, and I ensure that the next generation has all the tools to compete globally, because Indians should be competing globally. Big companies or multinationals would not build India. It would be the SME sector that would be writing the next India growth story. So that's what my mission is, to enable startups to lead the India story. Whatever little I can contribute, I try to contribute.
So that's not little, that's huge. One person can bring in so much change and can bring in so many people together to work towards one goal of making India again IP hub, as you have envisioned for everyone.
That's why I keep my Fridays open for 4 hours. Anybody can book a slot and they can ask questions without any charges. So that's something that attracts most people.
Wow, we would love to promote that aspect, and we'll definitely talk about this, the Fridays that you keep open for people to come to you and have that free consultation. That's something which is not easily available, at least from such senior attorneys who are already having such big portfolios with them. This is something which is very inspiring for young professionals also. So, sir, how would you like to talk about the intersection of science, innovation, law? And what kind of core skills that these young professionals can seek when they are trying or thinking of building a career, and what do you propose to build that particular mindset, and the kind of advice that you would like to give to them so that they can thrive in this particular field of intellectual property, keeping in mind that they also have to give back to the society as you already are doing?
For anybody to give back to the society, they should first focus on building their career and themselves. And they should enjoy IP, because this field is something that if you don't enjoy, you cannot work a single day. That joy, that kick, you don't have to drag to office any day. You just look forward to that. And for that, the basic for students or who are young professionals is that you should develop interdisciplinary fluency. You should have a passion for science, and you have an understanding of law, and you are able to look at business so that you are able to connect the dots. That's something that I always suggest, that it's not mastering one thing. You have to be jack of all trades. You have to be good at multiple things. Because if you go in one direction, if you are very good at law, IP is not for you. It's the core legal side. If you are good in engineering, IP is not for you. You should have a flair of multiple things. That's what IP requires. You should also cultivate a habit of deep listening, because majority of my clients would describe symptoms, not problems. My job is to diagnose both. They would just give me a situation that this is where I'm stuck. That's just a symptom. The real problem lies somewhere else. I need to identify what the root problem is and then provide a solution. Somebody has sued them. Filing a countersuit is not always the solution. There is also room for arbitration. If my case is not very strong, I would look for any other avenues where I could bring the other party to the negotiating table. So that's all a part of business strategy. And secondly, I would advise the young generation to stay curious, because IP is evolving rapidly, especially with areas like AI, genomics, clean tech, or majority of the new avenues that are coming. If you are not curious, if you are not rigorously reading, it will be very difficult to stay updated. This field needs you to be relevant. And finally, last but not the least, be ethical. Cutting corners is not going to make you survive long in this field. This field is built on trust. So if you try to cut corners, you might get one or two clients, or you might get one or two cases which would be a shortcut, but integrity would help you build a career. That's a must. This field rewards only those who are sharp and sensitive. It's not something that you should be ruthless. Those who can think like a scientist act like a lawyer and listen like a consultant. That's what I always say to anybody who is hired. You should have good listening power, but you should act like a lawyer and think like a scientist. That's what an IP lawyer should be. It's not a one-dimensional career, I would say. And I have been actively mentoring our juniors to understand what I call IP fluency. It's the ability to connect innovation, law, and commercial relevance. Because there is a brilliant invention that somebody has done, because most of the inventors are very passionate about what they have created. Is it packaged enough to be marketable as a product? An IP lawyer would stop before that. I go that extra step. How would the market perceive this? What would be the best sales strategy? If you could associate your product with some bigger brand, how would this complement? So those kind of strategies I come up with because I try to help the business grow rather than just limiting myself to the IP side. So if you are someone who is curious, ethical, and eager to make an impact, IP is the career for you. It's a very fulfilling career path, but choose wisely is what I suggest. Because we have also one very good initiative in our organization where we have weekly training sessions for everybody. Whosoever is there, they are given specific topics to present to the entire organization. Every fortnightly, we have sessions so that they get to dive deeper into that particular topic. So that is something that I have been doing regularly in this organization, because for me, it's all about the culture that we built. We are here to nurture, and that's what we have been doing.
Wow, what a beautiful thought process. I have kept note of it. So I'll start with the curiosity is the key. Thinking like a scientist, acting like a lawyer. So, keeping all that in mind, how have you developed this culture inside your organization and made sure that everyone is aligned with the whole process? Because it's a huge organization, it's in several jurisdictions as well. So, the kind of thought process that involves, it also involves the understanding of having a very good mental health as well as physical health. So, how have you worked on that and made sure that all your team members are not only aligned, but also following those certain protocols that you may have set? Because it has become a very big growing issue of having mental health problems as well as physical health has been compromised, and people have started talking about it. They are not talking that much. But we would request your views also for lawyers, especially, and keeping in mind the high pressure work that we do and the kind of work that has to be kept in secret also sometimes. So how do you work around that and make sure that you also stay healthy and make sure that whole of your team across the globe is also equally healthy?
It's definitely a journey, I would say. I've been trying hard to maintain a balance, but yes, it's still a learning curve. But I used to equate longer hours with more better outcomes. That was earlier. Over time, I have realized, or with experience, I could do things much quicker. And I have realized that clear thinking, a strategic approach, and I would say a strong leadership, that all together combines to form a structure which helps you remain fit. By fit, I mean mental health more, because lawyers get involved in a case so much that they are not able to shut when they are not working. Even in the subconscious mind, a case keeps on going when you are so involved. A setback in court would ruin your evening, which shouldn't be. So, a lot of time it happens, but now I take time and ensure that I switch off. I listen to music, go for walks, or the best I like is speaking to young professionals. So, that helps me unwind. And I have a supporting family. I have a very close group of friends. I have kids who help me relax. And that's how I keep my mental balance, I would say. They help me recharge, especially when things get intense. And it happens almost every week. So that's how it is. But delegation of work, and the other important point that I forgot was mentioned, building a strong second line. Because as the firm grows, you need to have a second line which takes care of majority of my issues so that I come into the picture at a very later stage. So that helps me go out and work daily, because prioritizing mental health is not about just myself, but it's all across the firm. Because if you are not sustainable, it will not last long. You will burn out. So we need to keep that flame alive, but that flame should not burn you, is what I always tell to people, that you stay motivated, but at least learn to enjoy. And that enjoyment should come. And I'm very fortunate to have a set of friends who keep me grounded. They don't let me fly too long. So that's how I relax and unwind. And stress. So that's how I have learned. I'm still learning. Scaling means having trust in your second line, having trust in your delegation, having trust in your processes and culture. And I'm very thankful that I have built a very good team. It's a slow and steady process. Every hiring goes through a lot of vetting. I'm personally involved in most of the hirings that happen in the company, because the culture should be intact, the mindset. You can teach a person, but you can't change the attitude. So that is one thing that I always look in people. Somebody who has not played any sport would not be a good team player, is what I feel. So these are small things that I keep in when I look for people hiring. I like to speak to them for an hour or so to understand and pick up some things from their minds. That person might be a brilliant asset, but if it's not fit in the culture, then he's not the person for me.
Amazing view, sir. Thank you so much for talking about building a very strong second line as well as delegating your work. Obviously, with the diligence and with the understanding that it will work after you have delegated. So, while you were talking about IP rights and IP management and other aspects of intellectual property, you also talked about negotiations and management. We would like to ask you about your thoughts about the arbitrations that keep happening in intellectual property, and how do you see the future of IP arbitration in India and obviously globally as well, because you have a global presence.
I have been involved in several IP transactions as well. And over time, I realized that your biggest competitors could be your potential collaborators in future. This is a big jigsaw puzzle. Every piece needs to fit in somewhere. And that is something that there is always room for negotiation, because nobody is outrightly against anybody. It's that everybody is protecting their own business interests. So in the broader sense, what we do is we try, as I mentioned earlier, I try to deconstruct the dispute. What is the major negotiating point? What is a strict no-go? Is there any chance where a financial negotiation could also take place? Because initially I was also involved in a lot of IP valuation work as well. So if this is a dollar value attributed to this particular piece of technology, could there be a royalty scope wherein we could have a negotiation around that? So arbitration is not always about having a mandatory step, because these days courts have been constantly pushing for arbitration and people should first try out arbitration before starting of the trial. But arbitration as a first step needs to be taken care of. The real challenge I feel in India is there are not enough trained arbitrators. Arbitration is a very specialized niche that is going to be very lucrative. There are very few expertise in that particular domain, because an arbitrator who specializes in aerospace would not be a good fit for e-commerce. So somebody who is domain specific arbitrator has been a wonderful experience working with some of the very good arbitrators, having trained in Singapore or Dubai, because those two centers, I really like the framework that they have, training of the arbitrators, the certification courses that they have. It's amazing. I've had the fortune of working with quite a few of them. And I wish India has that kind of a setup where we have training schools for arbitrators, wherein there is a specific coursework, 6 months, 8 months coursework, wherein arbitrators are trained to arbitrate. Because most of the times we have our own biases and arbitrators shouldn't be biased. So those are small things that arbitrators need to inculcate, and with training and proper guidance from the established institutes across the globe, India can be a major hub, because that would lead to a reduction in a lot of the backlog that we have in courts. If there is a good arbitration mechanism, in IP, I would say it's very laughable that most of the businesses, I would say 500, 600 crore businesses, they were started by a family. When they split, they don't have a proper agreement about IPR or brands. And that fight goes on. Those family businesses have involved in a lot of feud in family businesses, where the brand, who owns the brand later, is a real nightmare. Because many people don't understand the value of brand unless they see that they can't sell using that brand. Then the valuation starts. So it's still in very nascent stage in India, but I am very hopeful that the next crop would be more accustomed to and more inclined towards alternate dispute resolution mechanisms.
Sir, with the kind of experience and the kind of exposure that you are showing these people, and with the workshops that you do, I really do hope that there are many others who keep on doing it, so that we become that IP hub that you have vision for. At the very end of this conversation, I would really love to understand, how do you keep yourself updated with everything that is going around? How much do you read? How much do you interact with the international community? And what difference do you see in understanding similar points related to the intellectual property rights in different jurisdictions? Because everyone has a different understanding. And as you have worked in more than 80 jurisdictions, I'm definitely sure that you must have encountered different thought processes and different understanding about the same intellectual property being filed in different jurisdictions. So we would love to understand that aspect for our young professionals to learn from.
Definitely. Because IP is a global thing. It's not restrained. You need protection in multiple countries, but each country has a different law that we should understand. Each country has a different patentability criteria. Some things are patentable here, some things are not patentable here. Method patents are patentable in some countries only allow system claims. So this kind of thing where you are seeking global protection, if you don't have a bird's eye view of different jurisdiction, what is patentable in Japan might not be patentable here in India. Or let's say there is a business method patent which is allowed in US, not allowed in India. Software patents, we face a lot of issues regarding section 3D or repurposing of drugs. So all those things, you need to work with attorneys across multiple jurisdictions to understand. If you are starting with a PCT application, my team has been trained with US attorneys, European attorneys, Canadian attorneys, even Japanese and Chinese attorneys. So when we write a PCT, you have room to amend in that specific jurisdiction when you enter that. When you are trying to prosecute applications across the globe, if you are working here, most people would go and help you to submit with a foreign attorney without giving you the legal perspective. Let's say if you file in US with 20 claims, same application if you go to Europe, why to go with 20 claims if you have to pay additional claim fee for 5 additional claims, because above 15 Europe charges. In China, it charges above 10. Some people I have encountered in the past, it's against my profession, but I would say that just to justify the billing of $20,000, they write a 200-page patent. That invention was brilliant and beautiful, and that should have been protected across the globe. But the translation cost was so much so that the client could not afford to file in non-English jurisdictions. Only 9 or 10 countries allow you English. Rest all is local language. You get the translation done. Why to write a textbook when you are writing a patent? Be concise, be compliant, and think the business of the client rather than your billing is what I always suggest. So having a global perspective with regards to global filings has been the hallmark of our success, because our patents get prosecuted in multiple jurisdictions and we are the one who are responsible for all the jurisdictions. We would not say that we have drafted you as per the Indian law and the rest you take care with your local attorneys. Then you keep on having an office action after office action after office action, and you end up spending a lot without getting the patent because it was written in such a manner that there is very little room to go ahead. I'll tell you, these days I'm facing a lot of issues with Indian companies, I would say. They cut corners while they're drafting a patent. They come to us for making a response for a US office action. After our response, the claims are allowed, but the final objection comes that there is no support for those claims in the specification. You can amend the claims, but you can't amend the specification. A brilliant innovation goes down the drain because you have already disclosed most of the things. There are remedies that we suggest, but you end up having your cost at least 1.5 to 1.8 times. You try to save a few dollars and you end up spending a fortune. So that's something that needs to be told to the people and to the business community, that it's always a penny wise and a pound foolish, that kind of a situation that most of the Indian businesses are facing these days. And as you mentioned at the start, that they don't want to pay. They will pay. They'll pay when they are in a soup. Why to get in a soup? Have the preventive strategies first. That's my advice.
Why to get into a swing battle rather than pay upfront so that you are safer for life, I would say. I wish to really understand your thought and your motivation. How would you like to see the whole IP hub thing? Keeping in mind the kind of high profile cases that you have done, and you have already faced a lot of issues with these businesses, what would be your advice or what would be your strategy in order to make sure, or not only make sure, to see that particular IB hub in India in next decade or so? Because the kind of issues that arise, they are from the very beginning. And as you are mentoring so many, not only attorneys, startups and different businesses as well, how would you propose that, keeping in mind that government also is working a lot towards IP awareness? And how is it that young professionals as well as the seasoned attorneys can actually help in making this particular vision of yours a reality for India?
I would say that we need to shift our mindset from domestic first to a global situation. It should be global by design. Most of the people file PCT applications, and I have seen people who say that we have got a worldwide patent. So that's the level of awareness that they have, and they don't enter national phase and everything goes down the drain. So if you start with a global perspective, then only you'll be able to compete globally. That's why KAnalysis started. We came up with the idea, everybody laughed at us, that how can you manage through a single window so many jurisdictions? Step by step, team got trained, we got trained, understanding different countries, different jurisdictions, what kind of objections each country has. We have built strategies where you could save at least 40% of your cost if you plan your prosecution and global IP filing strategically. Minimum 40% saving that we have shown repeatedly again and again. That's a huge lot of money considering you are looking at 8 to 10 jurisdictions to file. India has made commendable strides. It's not that India has not done anything. At the time, it was no digital filing when I started. Now it's all digital. Expedited examination is a very welcome step that we have. They have increased outreach programs. That is very good. They have stakeholders meetings. That is a very welcome step. The major problem that I see is inconsistency in examination of patents. Delay has been something that I have always been, but now, at least with expedited examinations and all, I have been able to get patents within a year. many a times. So those are some things that have certainly helped. Just like USPTO, Indian Patent Office needs to adapt to AI for basic things. You can't replace humans, but at least the formalities check and all those things could be automated. USPTO has automated all those things. That would help us get a better outcome, faster outcome, and delay in enforcement. I empathize with the judiciary because they have a huge backlog, but Indian system legal reform is the need of the hour. If you want to be business friendly, you need to have fast track courts. IP divisions here in two high courts is a very welcome step. It's really, really helpful. But we need to have more dedicated IP courts across the country. And IP should be the prime focus of the country. Because if you want to become so-called Vishwaguru, then you need to focus on IP. If you don't do that, you'll not be a business-friendly jurisdiction. You'll be just a center for cheap labor where your manufacturing would move to somewhere else because they would be cheaper than you. Unless you innovate, unless you try to remain attractive to innovation, you create an ecosystem for innovation, you'll just remain like that. We have seen examples. Malaysia was one such country which could not innovate. It rose very fast and then stagnated, phased out. They were calling it the next bright spot. Innovation would sustain. US hardly makes anything. They innovate. So innovation needs to be nurtured and at the very grassroots levels. School curriculum should have at least a course on IPR. I tell my kids a very fascinating story. They were making some paintings at home. So I told them always sign your painting, otherwise somebody else would take a credit. That's IPR. So that's something that we need to inculcate and create right from the initial days, that anything you create, it's your intellectual property. And think beyond. And our education system also needs an overhaul where we have relevant courses that is more aligned with the industry requirements. That is something that I look forward to with this government. Let's see how much they do.
They will definitely. Thank you, sir, for being here. And thank you for eating, breathing, talking, living intellectual property. It's something which is hardly seen, but I really do hope that this dedication of yours not only goes through your organization, but it goes through whole of the India, and we get that particular IP hub at an international level. And thank you so much for carving out this much time for our team and for us to listen to you and to see the passion that you have for intellectual property and to talk about intellectual property rights, talk about IP monetization, IP valuation, and what not related to IP. So hence you breathe IP. Thank you so much, sir. Thank you for being here.
One thing I would like to add into the end.
Sure, sir.
We should learn to celebrate innovators. Like we celebrate a lot of things, we should have a national program to celebrate innovators. That would be really an encouraging sign for anybody to innovate.
So on that note, I can only request KAnalysis to start with that particular celebration of IP and innovators. And I definitely hope that you will think about it. And it has been an enriching experience today to know and learn so much about not only IP, but how you can actually monetize and make it a business proposition and make it so big. From humble beginnings to absolute heights. Thank you so much, sir, for being here.
It was an absolute pleasure speaking to you.
Thank you so much, sir.
Thank you so much.